Hello, and thank you for joining us for another episode of This Week in AML. I'm John Byrne, Chair of the AMLRS Advisory Board.
And I'm Elliot Berman, our Creative Director. We are excited to welcome you to the This Week in AML podcast,
where we explore key news and developments in the global financial crime prevention community.
Hey, Elliot. How are you doing today?
I'm good. How are you, John?
Well, we're both in Buffalo, New York, in one of our offices for AML Right Source, looking over at Lake Erie, which is pretty exciting to see all the boats out there. So we're here for an advisory board meeting. I think many of the folks hopefully listening to this have heard from a number of our board members who have been part of webinars over the past couple of years. And part of our strategy tomorrow is to plan future content programming for the next couple of years. So we're excited. And we haven't actually had an in-person board meeting since May of 2019 because of COVID. So
that's right.
But we got a chance today. There was a bunch of things that went on during the week. I did see that there was a speech given by the acting comptroller of the currency on cybersecurity issues. So I tell folks, take a look at that when you get a chance. But there was a couple of pieces that we talked about regarding sanctions, and two particular pieces. One was an op-ed piece in the Washington Post, and the second is the most recent. I say the most recent because these things probably come out every day, but Treasury announcements on sanctions.
Correct.
So I know that you read the op-ed piece. It was written by Ingrid Worth, I believe that's how she pronounces her last name. Among other things, she's editor-in-chief of the American Journal of International Law, and she talks about the fact that there's a lot of comments about designating specific oligarchs in Russia about being state sponsors of terrorism, and you see that a lot. You see a lot of both sides of the aisle saying that this is something that the president should do or Treasury should do, what have you. She takes a different perspective. She says there's actually some negatives behind the designation. Do you recall some of her points there?
I do, and it's a little bit of a technical explanation, but I think oftentimes, the technical stuff behind the idea is really where you need to go to understand whether the idea is a good one. So, the author acknowledges that the statutes and the rules are very technical and you need to dig. But she points out that what would happen as being designated a state sponsor of terrorism is it would take away some of the immunity that foreign governments have from being sued by U.S. citizens in U.S. courts. And what happens is then there would be opportunity for litigation. One point she makes is that the approved litigants are very limited. They'd be U.S. persons, or they would be members of the U.S. Armed Forces, or other U.S. government employees. So that's a pretty narrow group. Secondly, that to the extent that any members of that group were successful in this litigation and could get damages, they would try to collect those damages from frozen Russian assets, which isn't a bad thing, except to the extent that the call for this is being done in the context of helping Ukraine. No Ukrainians would be able to access the courts through this change in the immunity. And the pot of frozen Russian assets that might someday be accessible by the Ukrainians other ways would be diminished by any successful suits by U.S. persons. So I think her point is in large measure that it's not exactly what everybody thinks it is when they say that they want to equate them with North Korea, for example, who's another designated state sponsor of terrorism.
Yeah, not that different from the debate about domestic terrorism, right? Because, and I've been, quote, guilty, unquote, of this as well, saying we have to start labeling things for statutory and other reasons. But some on the other side say if you do that, there's already current statutory tools that can be utilized, and so have we utilized those to the degree that we should? And it's much more nuanced, kind of like what the professor has written about here, in terms of it not being that simple of a solution. So,
right. The other component of all of this that you mentioned is that there are existing tools that the U.S. and other countries have used against Russia, sanctions being the best example. And there are, we've talked a lot about those sanctions since the war started. And as you mentioned yesterday or the day before, the Treasury issued some more sanctions, again, aiming at some individuals who are closely aligned with President Putin, and also identifying some organizations for further sanctions as a result of their efforts to evade existing sanction programs that impact them.
Right, and the press release around this actually specifically says sanctioning elites and companies, but pointing out that part of the reason is because they generate substantial revenue for Russia. So it's obviously, as we know, sanctions are a way of getting funding away from a variety of criminals. But they make that point here. So they list a number of the, quote, elites that are close to the Kremlin, and that's listed there as 5 or 6 of those. And then there's a section on sanctions evasion attempts. And if hopefully some of you have already listened, we did a podcast last week with Kit Conklin, who talked about export control evasion and the reason why FinCEN and the Department of Commerce issued a joint alert. So this is sort of consistent with what the Treasury and other agencies are focused on, including FinCEN, and that's, you issue these sanctions, but then when there's attempts to evade those sanctions, there's additional penalties for that as well.
Correct. I think the summary of all of this, or these last 2 items that we talked about, is really that this is not going to go away anytime soon, maybe ever. And the U.S. and other governments will continue to look for tools that are effective. And as we either create new ones or use existing ones but apply them to this situation, it'll be important for us to really understand, not only at the policy level, but at the technical implementation level, what the result will be and what the impact will be.
Oh, I no, totally agree with that. And as we've always said, sanctions is not as simple as it seems. Some have characterized it as sort of an administrative requirement that if you mess something up, there's a penalty. But it's a lot more nuanced than that. Some of it is the tools, the technology that you use, the ever-changing additions, hardly any deletions, but additions of sanctions. And then there's a long debate, and the professor does cover that early on in her piece, saying that there's some question about the value proposition of sanctions. She's not saying that there is none. She's saying that's still to be determined. So specifically regarding Russia and Russia's attack on Ukraine.
Right.
So
yeah. Sanctions in the U.S. as a tool of foreign policy in one form or another have actually been around since the Civil War.
Right.
And so different administrations have used them differently for different circumstances. Some stand for a long time or are meaningful for a long time. I think a good example of that is the Cuban sanctions, which have been in place now for many, many years. Some, even if the program isn't turned off, the focus of it fades away a little bit, and so its impact lessens because circumstances change.
So take a look at that. I think, as we always say, you should be subscribing to the Treasury Department's plethora of press releases. Obviously, we focus on AML sanctions, the CTF, but obviously they are in the thick of things regarding the economy. So if that's of interest to you, a lot of good information there with Treasury. Obviously, OFAC issues things virtually every day as well. And I'm sure the OFAC experts listening to this already know all of this, but those of you that work adjacent to that space, just to be on top of things and understand what's out there probably makes a lot of sense. Coming up for August on the August 25th. Will be a webinar that we're putting together. We're excited about this, as we are all our webinars, of course, but this one is going to focus on the concept of some of the laws and regulations designed to increase transparency and where they sit based on a practitioner, Jonathan Lopez, former DOJ lawyer who's now in private practice, and Gary Coleman, who's with Transparency International and Advocacy Group. And I'm going to talk to both of them, both about the practical issues with the push for transparency, whether it's shell companies, more reporting, and all that. And Jonathan's take on, as he represents clients, what are some of the regulatory and compliance challenges. So we're going to give you some excellent, we hope, practical advice that day, August 25th. You can register on our website. And we've got some more things coming up in the next few weeks. I hope to be doing an interview with Steph Casella, who is probably the preeminent expert on asset forfeiture. We're hoping to do that third week of August. It's when we'll record it. Obviously, we'll try to get it up and posted maybe early September. That's another area, sort of like sanctions, which is not off to the corner, but asset forfeiture is something that people talk about, but I don't really understand how it's practiced, the value and all of that. So we talked to Steph a few years ago, and there's been a lot that's happened in the past couple of years. So he's going to update us on what's going on, not just in the U.S., but globally.
Great, John. So next week we won't be together, but we'll be back. You'll be able to hear us again a week from this Friday, and ideally every Friday. So look forward to talking with you and actually having dinner with you, which I haven't been able to do in a long time.
Take care, and you'll be on vacation next week, although we'll still talk. So enjoy your vacation.
Thank you very much.